That is case number 107904, State of Kansas v. Terry L. Bowen.
May it please the Court, Joanna Labastida of the Kansas Appellate Defender Office for the appellant, Mr. Terry Bowen. If I may, Your Honor, I'd like to ask for 3 minutes rebuttal time.
3 minutes is granted.
Thank you. Just as a very quick matter regarding Issue 3 and the state's contention that it was not preserved for appeal and I did not discuss any reason why this Court should reach it for the first time on appeal, I would take issue with that. And although it's maybe not in the proper format that this Court desires with the preservation of the issue and then the standard of review, on page 25 and 26, I did discuss that it is a fundamental right of the defendant and that it could be raised for the first time on appeal. That is the jury.
You're referring to the jury question?
Yes, Your Honor.
And what was it handled in this manner that the question was asked from the jury, court received the question, called counsel and defendant in the state, and they reviewed the question? Is that how that worked here too?
I believe so.
And then the note was then handed to some court bailiff and handed back to the jury.
That is.
Now, I'll ask you the same question. Are you aware of anywhere that does it any different than that?
I have noticed recently that the district court is calling the jury in to answer the questions now. And I don't know if that's because Wells came out and basically, but prior to that, it was common practice for just the answers to be sent back.
Right.
I've noticed. But yes, recently I've noticed that they've been calling the juries back into the courtroom.
And typically the practice is the question and the answer is then recited on the record. Counsel has a chance to address the question and then it's put on the record. They can raise any objections and the note is then handed back to the jury. That's typically how it's done.
Yes.
Okay.
That has been the practice before. And I believe our argument would be that because it is sent back, the bailiff or the administrative assistant, whoever is given that duty, may not understand that that person is not supposed to add anything or change the answer or answer any additional questions on the spot. And because
kind of a chain of custody.
Well, we don't know what happens back in the jury room, and that's not on the record. So it's almost impossible for the defendant to discuss what the error would be in that specific case, and rather that it should be viewed as more of a structural error situation.
Have you any information about that, though?
I'm sorry?
Do you have any information about that? I mean, for example, do you know what the oath of the bailiff was, or is there any information that the bailiff didn't follow their oath?
No, we don't know.
And why should this be an issue we would discuss for the first time on appeal? Why wouldn't we require some information? I mean, I understand your structural argument error, but before we cast doubt, shouldn't we have some information?
Well, we argued that it's a fundamental right to have a public trial and be present for those.
I understand that, but the right to a public trial has not been completely denied here. And I think under the U.S. Supreme Court case law, they narrow that to look at the circumstances of the particular offense. And are you aware of authority that says this, anywhere that with this particular offense, that this is a structural error? If the answer has been, the defendant has been present during the discussion of the answer, and all that is happening outside the courtroom is the passing of the court's written answer.
I think our argument is more that it's akin to structural error because we don't know what happens for sure outside of the court. And I agree that there is no specific indication in this record that the bailiff or whoever was charged with that duty.
A contemporaneous objection at trial would have given the opportunity to have asked questions of the bailiff to determine that, wouldn't it?
That's correct. And that was not done in this case. But nonetheless, I would argue that this court could reach it for the first time because of the fundamental right to a public trial, a present judge, and all the other arguments I raised in the brief.
Is there any indication that was a closed proceeding? That, I mean, you're saying it's generally these are cast as the defendant wasn't present, or there was some indication that he or she was not a part of that process. You're raising it as a public trial question. That the public has a right to be a part of this procedure.
To be a part of the actual answering of the
public has
questions.
a right to be be aware of what is transpiring during the question and answer dialogue, or whatever is how you ever want to characterize it.
Well, it was public in that the formulation of the answer was in open court.
Right.
I'm arguing that the actual giving of the answer to the jury, there might have been some changes or added questions or whatnot.
So it's that kind of public declaration of what the answer is that's the problem here.
Right.
Okay.
Well, it's the communication.
Right.
Yes.
And what would be the policy behind that? That you've got the transparency of the public has the right to be there when the answer is formulated, and what does it add to the calculus that the public can be there when the answer is handed or read to the jury? I don't understand the.
I guess I would focus more on the defendant being present as well.
But that you're making the argument about public trial right
Right.
now, and we understand the argument about the present at all critical stages. But this is a different argument you're making with the public trial.
I guess my position would be that the public trial aspect is important in a situation where the jury might have additional questions and are asking those to the bailiff, and so that's not public. The actual communication between the bailiff and the jury, and any additional communication that maybe the jury doesn't understand that they're not supposed to ask to the bailiff directly, or that the bailiff doesn't understand they're not supposed to answer any other additional questions, that potential situation is not public, part of the public trial.
Very often, attorneys will talk to the jurors afterward. I mean, there would have been means and could have deposed the bailiff. I mean, there was ways for the defense counsel to determine whether there was any mischief in the communication.
Right.
And I think what Justice Luker was trying to say is, or the point she was making with the objection, is that we don't have the facts that we need because there wasn't an objection. And it's not just that it's a fundamental right, but it's also that we don't have the facts we need to review.
I agree that in this particular situation, there aren't facts that aren't on the record, at least, that could potentially show what error occurred back in the jury room. It was a common practice, and potentially still is a common practice, to send a note back. So I don't know if the defense attorney would have even understood that he should have objected to that particular answering of the question. At this point, I would just argue that because we don't know what happened, that's what makes it akin to a structural error.
I just want to clarify something you said earlier. Is it your position that the right to a public trial demands that the jury's questions be given orally?
Orally on the record in open court.
They cannot send out a written question?
Well, because, I mean, the jury's practice in the jury room, that is a different aspect to the public trial, I think, and their formulation of a question is often read on the record in open court to the judge and the parties and whatnot. But I don't know if the formulation of their question needs to be on the record. It is read in open court. the actual question is. I don't know if I've answered your question.
Yes, I thought perhaps you were going further than typically of, as you said, taking the question, the judge reading the question on the record, to suggest that the jury itself had to articulate the question in open court. So I just
Although
wanted to
I
clarify
think I
that.
have seen that situation where the jury comes out and asks the question on the record, but I couldn't tell you what record that was or what case or anything like that. I apologize.
I have a question on your structural error argument, just the statement you made a moment ago.
Okay.
You said because we don't know, that makes it look like structural error. This is a knowable thing. Structural error tends to be in situations where it's not knowable. Here we just don't know because nobody asked, right?
That's correct.
Okay, thanks.
And just to, again, clarify, not the, a jury instruction in most trials covers this issue, is that the court instructs the jury that if they have any questions, they can communicate, and I believe it's in writing, to the court, isn't? And I don't know if that jury instruction was included here, but typically that's a part of the jury instructions.
If not included in the instructions, it's often told to the jury while they're departing for deliberations.
But almost always, I believe it's a part of a written instruction.
Right.
Yeah, okay,
I don't think that changes the analysis, though, of answering the question.
right, understand.
I don't have much time left, so if the...
I want to move you over to the conflict of interest allegation regarding the preliminary hearing and in continuing our string of questions about structural error. You claim that's a structural error. Your authority for that is State versus Jones, and that's a self-representation case. And we're not talking about self-representation here. So first of all, do you have any authority that when we're talking about successive representation that might create a conflict, that is viewed as structural error as opposed to reviewed under typical Strickland or Mickens kind of analysis where we would consider adverse effect or deficient or affecting the outcome? I mean, I don't think your authority supports the structural error claim that you make. And so do you have any?
I guess I was using Jones as for the notion that a violation of the right to counsel is subject to the structural error analysis.
But that's not the test we use for these kinds of factual situations, is it?
Well, no. Specifically, ineffective assistance of counsel would be dealt with differently.
Have you made any argument that counsel's performance during the preliminary hearing was deficient or had an adverse effect? I didn't see any argument in your brief about that. I saw you rely on structural error.
Right.
So if we don't agree that there's structural error, we don't have anything to work with.
Well, I would argue that there was a situation akin to structural error, maybe not in the sense that it is actually structural error, but because similar to the answering of the jury question back in the jury room, we don't know what a non-conflicted attorney could have done in the preliminary hearing. And that's...
I don't understand that because you've got the preliminary hearing transcript and you know what the witness is saying and you know who the witnesses are, and if there's some reason to believe that counsel's performance was deficient or if there was some adverse effect, it seems to me you can read it and point to it. I mean, we do that all the time in these cases. And so you haven't done it in this case, and so I'm wondering if we disagree with you on the law, are we just done?
Well, I suppose I didn't give you enough reason to suspect that a non-conflicted attorney could have done something differently. I would have to agree that if it's not structural.
And then let me ask you one other question. Do we know at that stage of the proceeding that there's a conflict? And here's my thinking. This is a preliminary hearing. We don't even know if the defendant is going to be bound over for trial. And so if he's not bound over for trial, then these convictions that the lawyer had been the prosecutor on would even be in play. So do we really have a conflict of interest? I mean, that's one of the arguments the state's making, is that there's no conflict, and I guess I want you to address that.
Yep, absolutely. I I guess I have a problem with the fact that prior to the preliminary hearing, Mr. Bowen was basically, the district court addressed a conflict and asked him to waive that conflict improperly, I might add, and I did address that in my issue, that there was a conflict, everyone agreed that there was a conflict and that he waived it improperly.
I'm not sure I agree with that, because when I look at the transcript, the state seems to just be not saying, yes, there is a conflict at this point. It seems to be saying, we're afraid there might be some issue about this. We just want to get it out that there isn't and that the defendant doesn't have a problem. And I think it doesn't come until, as I read the record, and correct me if I'm wrong, it's not until after the defendant's bound over for trial that the state comes in and says, hey, we're going to use these convictions. And so counsel is possibly a witness, but certainly that there's, in his prior representation, he's got a problem now, so we want the defendant to have a new lawyer. I mean, the state was making all those arguments. So that's why I'm trying to make this, wondering whether there's a subtle distinction here between prior to the preliminary hearings outcome.
Well, I don't know if this answers your question in particular, but I guess I have a problem with the notion that the state has control over whether or not my client's attorney has a conflict now.
State's not saying there's any. I don't see that as an argument.
Well, by using his prior convictions at trial, they have now made the conflict more concrete, for sure, because his attorney could be a witness against him for the state.
There's no bad faith in that. You're not claiming any problem with that. I mean, that would be.
I'm not claiming bad faith. I'm arguing that that I have the argument that it shouldn't be the state who decides whether or not there's a conflict, and that the conflict existed no matter what the state would have done at preliminary hearing. That's my argument, that there was a conflict. It wasn't waived properly because it wasn't done according to the rules, and we don't know what potentially could have changed.
What were the rules that weren't followed?
That a potential conflict needs to be done in writing after the defendant is advised of all the possibilities and agrees to that waiver. And it's, I believe, Rule 1.9A, and then I've also cited 1.11A.
Was that in effect at the time of this trial? Those rules were, that rule was amended fairly recently, like two years ago or so? Was the writing requirement in effect at the time of this trial?
I don't know that off the top of my head. I guess I assumed it was, but I can double check that and address that in a 609 letter if the court.
That's okay. I mean, that's easy for us to look at. Assuming we would apply the adverse effects test of Mickens or a Strickland change of outcome test, in other contexts, we have said that error at a preliminary hearing is harmless if a defendant is later convicted.
Right.
So given that line of case law, would that apply as we look at a Strickland or Mickens test?
I briefly addressed that in my issue, that basically the conflict was at such an early stage in the trial. We don't know what a non-conflicted attorney might have done going forward with the possible changes at the preliminary hearing, what testimony could have been addressed. So unfortunately, that's my argument, that we simply don't know, even if this court thinks that that could have been cured at trial.
We have county attorneys and district attorneys that move on into different areas of the law and move into private practice and then take up defense work. And in the same jurisdictions, in the same, that's a fairly typical and common occurrence. How is it that and so it's also a common occurrence that when counsel in that capacity is then appointed to a case or was retained on a case, that there may have been a prior representation as an adversary to that particular individual. Does that always create a conflict? And where is that line drawn? It seems to me that that's not an unusual occurrence. Happens fairly frequently, actually.
I agree. In this particular situation, though, those prior sex crime convictions that Mr. Bowen had were being admitted against him in this trial.
Right, but not.
We don't always have
But
that.
there was no indication that was. Justice Biles pointed out there was no indication that was going to occur until after he withdrew. I mean, that at preliminary hearing there was no indication that his prior activity against his client was going to be used. And does that then preclude him from being an effective advocate at preliminary hearing?
No, I don't believe so, but I
Well,
guess...
he would be an ineffective advocate if he didn't know about the prior convictions and anticipate he was going to have to defend against them, wouldn't he? I mean, defense counsel needs to know what he's dealing with his client.
And
Thank you, Justice Johnson.
that was a better answer than I could have provided, I'm sure, but...
Well, then let me ask you this. What else, when you said he needed to have the advice of conflict-free counsel, what else did Mr. Bowen need when he waived at preliminary? And he specifically said, I waive the conflict. What else did he need to know other than knowing that his attorney had prosecuted him previously and knew all the bad things about him? I mean, there's nothing else that he really needed to know to make the decision whether he wanted to go forward with this attorney or not, is there?
Well, I think he needed to know all the ramifications of having a potentially conflicted attorney. The state would argue that he was only potentially conflicted at that point. The ramifications of that being that you might not be able to move forward with this attorney in the future if things play out the way that the state wants. I don't think that Mr. Bowen was given all of the facts of what a conflicted attorney would have to do or what would change in his representation based on that. It was such a meager discussion about the conflict, and the waiver was not, in our argument, would not be knowing, and it was definitely not in writing.
And the writing part is part of the rules of professional conduct.
Yes, Your Honor.
And haven't we said that those are disciplinary rules and they don't govern the outcome in a trial?
I think, though, it shows a situation where a defendant is giving a knowing waiver, though, that everything has been outlined for him and he understands exactly what he's doing. It definitely goes to that factor. I am substantially out of time here.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
The state appears by Assistant Solicitor General Natalie Chalmers, and unless this court has questions about the other issues, the state intends to mostly focus on issue 3, the jury instruction answer, or the jury question answer, and then maybe on the conflict.
Well, on the conflict, how do we ever know what questions an attorney did not ask because of prior knowledge or prior experience or of a conflict? When we're talking about looking at a record to disclose whether there's been prejudice, how do we ever know what questions were not asked?
I think that is easier to prove, say, if the same conflicted attorney went to trial, but a preliminary hearing, why would it be any different? All we're doing is probable cause on the actual charge. I don't see how...
Well, that's, in the real world, preliminary hearing is also used to establish some discovery on behalf of the defendant to use to impeach witnesses at the trial. And how do we know what questions weren't asked for purposes of discovery or purposes of later impeachment or because of the conflict there? And we know up front regardless of whether you use 6455, you know up front those prior convictions are going to come into play at sentencing if there's a conviction. So this attorney knew that if they went to trial, had a sentencing, which is certainly a likely scenario, that at sentencing, he would have to be arguing against the convictions that he had obtained himself.
But he wouldn't necessarily have to argue against the convictions. The facts of the prior conviction may or may not come in, depending on, or may not be contested. I don't know why an attorney would have to be a witness to the prior conviction. As Justice Rosen points out, this is common practice in smaller counties. There is no rule that the state is aware of that says just because you were prosecuted somebody, you can't
I'm not saying just
defend them.
because you were, but I'm talking about this case. At preliminary hearing, this attorney had to know that those prior convictions were going to play into this prosecution of this client, or there's incompetence there for not seeing what's going to come down the pike. I mean, the attorney had to know up
Competence,
front
though,
that-
requires, sorry,
Counsel,
I'm sorry.
please proceed, Justice Johnson.
No, that's it. You know my question. The attorney had to know that these convictions were going to play a role in this case. Had to know up front.
Should have known at least, yes, but that still doesn't, for ineffective counsel, you still have to prove prejudice. There's no proving of prejudice here. There's no even an argument that there was prejudice or adverse inferences. This is not the structural error where there is a concurrent representation. The defense attorney was not representing the state at that particular time. It's their burden to prove an error, not mine. It's their burden to prove some kind of adverse or prejudice, and they haven't done it here. They haven't even alleged it.
What is your position as to the test we apply in a successive representation situation?
Not structural error. I don't know that that question is actually, it's open. It's an open question right now, I believe. I don't think it's been answered. I would think it would default back to similar to Strickland, or at least the adverse inference. One of those
Adverse
two.
effect.
Adverse effect, thank you, sorry.
And I want to, let's start on that, because I read your brief as taking the Strickland higher approach. So is that what you did, or did I read it wrong?
No, I did use Strickland, and then I think I said at the end, but they didn't do either one, I think. I think I used Strickland because they weren't advocating for any other. They just said structural. I went with Strickland. And because it's an open question, this court's free to do as it wishes, but I do think that especially when there's a conflict and there was a waiver here, it's really hard to discern, and it was a preliminary hearing, that it's hard to say that this so infected the trial that he should automatically, structurally be reversed.
Don't we have a little better window about what counsel could have done, because this was a consolidated preliminary hearing and we had other lawyers running around in this proceeding doing, asking questions of there were only two witnesses at the
Correct.
preliminary hearing, and in terms of probing about impeachment, we had two other lawyers representing two other defendants.
Yes.
Going there, so we do have some measure there. I guess I'm getting back to the Strickland or the adverse effect thing. We have at times held the state when it has recited the adverse effect test in these situations and just said, well, since everybody's using it, we're going to use it. And I'm trying to figure out, did you make a conscious decision to take us to the higher standard so we couldn't do that to you?
I can't remember if I did in this brief or another one. I know that I've read many cases that say the state has only said adverse effect, and so that's what we're going to use. And then I did go on and argue that there was no holding on that, and then pick Strickland. So I think I made a conscious decision, but since I didn't specifically state it, I can't remember. And as to the waiver, whether or not the rules of evidence are not the same as the constitutional requirement for a knowing and voluntary waiver. So the state would say that this waiver here was sufficient constitutionally to protect the defendant's rights to effective counsel. If I could move to the jury instruction, defense counsel is right. I overlooked her statement that she did argue an exception, but only to the public trial. She didn't do it to the impartial jury the impartial court judge or the right presence of the defendant. I do think, however, this court made very valid points as to why this shouldn't be reached for the first time on appeal. It is something that should have been objected to or discussed after trial, maybe might have motioned for mistrial if they found any error in the proceeding. But I don't think it should be addressed for the first time on appeal here. And as to some of the questions, yes, this is popular practice throughout the state. I know that because I review all the briefs, and this is a very popular issue throughout the state as well on appeal at the moment. I do think after King, some district courts are being more cautious and actually, once there is an answer, answering in open court, calling the jury back in and answering the question in open court.
And do I recall correctly that you added a harmless error alternative argument after King came out?
I did in a 609 letter.
Yeah.
Or tried to, yes. And as to the right to be present, Wells and King are, I'm not sure that King overrules Wells, because even King itself cites Coyote, and Coyote says that the question can be answered in writing. There's language to that effect. I'm not sure that this court has ever held that answering a jury question in writing after it's been discussed in open court is error. I'm not aware of any case in any of the 50 or in any other jurisdiction that holds that that is a right or a violation of any right, the right to public trial, right to defendant to be present, anything like that. I could not find it. As to the right to the public trial, the answering the question in writing does not violate any of the major protections of the right to public trial. This court in Dixon said that a right to a public trial can be harmless error, but I don't think they meant it, because in Dixon they didn't apply a harmless error standard, but at least a common understanding, because they said it wouldn't have affected the trial. I think what the Dixon court did, maybe inadvertently, was essentially pick up the Second Circuit's triviality standard and then say that the reading of the verdict in open court was not trivial. So it was a structural error in that case. Here, if there is any error, it's trivial. We have the answer was opened, or the question was answered in open court with the presence of the defendant. All the judge did was put it in writing and deliver it and follow the statute that allows bailiffs to communicate, well, to pass notes, essentially. No other communications allowed. It is now part of the record. We know exactly what the answer was. There's absolutely no showing here that it affected the trial in any way, shape, or form. So even if this court finds error, the state would urge this court to adopt the triviality standard that the Second Circuit has adopted. As to the judge's absence from the trial, I don't really understand that argument. The judge was there, he answered the question. I'm not sure why that would be error at all, but if it was, it sure should not be structural error or reversible error. And also, back to the right to a public trial. The right to a public trial is usually the courtroom has to be open. And in this case, court has reversed cases before, it's because the courtroom has been closed to the public. There is no indication here that the courtroom was ever closed, so thus I'm not even sure that the right was ever violated. Unless this court has any further questions, the state would ask that you affirm conviction in this case.
Any more questions? Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Just as a very quick matter, and I'm probably beating a dead horse, but I did address the raising it for the first time on appeal as to the right to a public trial and the right to an impartial jury. I don't know if perhaps the state overlooked that, but in any event, this court has addressed that for the first time on appeal in other cases, and so I would argue that it's able to in this case as well.
Does that conclude your presentation?
Yes.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.